Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Rossi. He's got a couple ladies that are kind of sparring on the way to church. I'll let you guys watch.
We are here in the case of Kimona Jones versus Lakeisha Kearney, case number 25-00173PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on the respondent, Ms. Kearney's motion to terminate a personal protective order that I granted in favor of Ms. Jones back, it looks like, on or about January of this year. So I do have both parties present today, and the way I think I'm going to proceed is I do have the objection here. I'll take some testimony from Ms. Jones because it's her burden to support the protective order with the two incidents of harassing or threatening conduct, and if necessary, any responsive testimony from Ms. Kearney, and then I can make my ruling on whether or not the protective order will remain in place after today. I do note that there is a alleged violation, and we've already set a separate hearing on that violation. I'm going to keep that separate for the time being, though I can certainly arraign that at the conclusion of today's hearing and advise Ms. Kearney of her rights with regard to the next hearing, and maybe we can just simply set that. Have I already done the order to show cause on that one, Lisa?
No, it is scheduled for a show cause.
That's going to be a show cause. Actually, I can't take
Yeah.
care of that today because that's pretty short. But let me take care of the termination. We'll take them in order. Ms. Kearney, I'll swear you in first and take you, or I'm sorry, I'm going to take Ms. Jones' testimony first, and she's the petitioner. Ms. Jones, if you'd raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right. And would you state and spell your full name for the record, please?
Kimona Jones, K-E, M as in Mary, O, N as in Nancy, A. Jones, J-O-N as in Nancy, E-S.
All right. Thank you, Ms. Jones. And Ms. Jones, I went back to the original petition for the protective order. And of course, you're required to identify two instances of threatening or harassing conduct in order to sustain this. The first one you testified to was a confrontation that started when you were on the way to church, and Miss Kearney followed you, and then a confrontation ensued. Why don't you tell me what happened in that case?
We had an altercation, a verbal altercation outside her home. And when I left her home, she followed me to church. And I rode past our church to kind of avoid the conflict being with the members walking inside. And it turned physical, and there was a lot of words exchange. There were people who were on their way to church, and they came and kind of diffused the situation. I went over one of the members' homes afterwards, and she followed me over there, yelling for me to come outside. She was sending threatening text messages to my phone.
Okay. Now you said that all started outside of her home?
Correct. We were meeting at her house. She asked me to return her. We were friends. We had a tenure of a friendship, and we just had an argument that escalated where I called her out her name, and she called me out my name, and I took off. When I took off, she jumped in her car to follow me.
She followed, and the confrontation occurs. It looks like you stated you got out of your car after you stopped on Garden Street and got out asking her to stop following you. Your statement in here, she swung at you and that forced you to defend yourself, i.e. fighting back. Is
Correct.
that still your statement as to what happened with the confrontation?
Yes, sir.
Okay. And then after that confrontation, you said there was still some following, and an hour after, including, her following you to perhaps another church member's home, and yelling at you to come outside. You said in the petition for round two, I take that you took that to be additional fighting?
Correct. That's what she was requesting.
Okay. All right. And, for purposes of a PPO, it's the law is not as obvious as it probably could be. It considers everything that kind of happens in one back-to-back incident, even though there were several different locations that it happens, it's all one incident. So I'm going to count that all as one incident. You also stated in the petition that there were text messages threatening to beat you up on December 10th. How do you know those text messages came from Miss Kearney?
Well, as I stated, we had a friendship, so her phone number is in my phone. She's in my
Okay, so
contacts.
it showed up as her.
Correct.
And can you, do you still have copies of the messages?
I do. I tried to figure out how to upload them on that court. That whole system is kind of
Yeah,
new.
our whole evidence
Yes,
document
yes.
thing. No, you're not the first one to struggle with that, I can tell
Okay.
you.
I definitely have the text messages
All right, why
from
don't you
her.
state to me what she said to you by text on December 10th?
All right, I'm gonna go to them now. December 10th it's very lengthy.
All right, read me the highlights if you can, the threatening part.
Let's see here. Okay, so I left your miserable saggy pants tail alone to keep from seriously hurting you. But I see you want these problems, so you gotta see me for round two. And this time nobody gonna be there to save you. Lying, telling people you with me. I missed when I swung. You don't know it's people out there that saw you. I have a recording of me telling you to get out your car several times, and you didn't get out till you knew people would get me off you. I hit you in your mouth like you're gonna get again since you can't keep your name out my mouth.
All right. Well, I think that suffices, certainly as what I would characterize as a threatening text. And that came directly from Miss Kearney to you as your testimony.
Correct.
All right. Well, let me get Miss Kearney's response. Miss Kearney, if you would raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. Miss Kearney, what's your response on these two incidents? In your request to terminate, you say that you're not a threat. I would say, when you're asking for round two, to me, that seems like there's at least a threat of a fight. Can't say who's going to win the fight, but to me, it sounds like a threat of a physical fight. Do I have it wrong?
You're not wrong, but we did have, as she stated, I texted her and asked her if I could have my house keys. I didn't want anything to do with her anymore. She came to me. I asked her if we could meet so I could get my house keys. She came to meet with me so I can get my house keys. That's how it escalated. She was upset because I didn't want her to be around me or my children anymore because of a lot of things that she was doing. So I was revoking her access to me. She wouldn't give me my house keys. She made a scene in front of my house. My neighbors were coming outside. As far as her saying I followed her, Your Honor, we attend the same church. That's something that she didn't tell you. I did not follow her. We had Bible study that night. Although I was not going to Bible study that night, I was dropping my children off at Bible study.
Got it. And you happen to be at least in the same proximity, it looks like, in the vehicles. Was there a point where the two of you get out of the vehicles and there's a physical fight?
Yes, it was.
Okay.
She got out of her vehicle. She was very upset again because I wanted my house keys and wanted nothing else to do with it. We did have a good friendship at first, but again, there were a lot of things that she was doing that I didn't want to be a part of anymore. So because I asked for my house keys, she was upset, calling me out my name. It did result into a physical altercation. As far as her saying I followed her to a church member's house, she texted me. I still have that text message. She texted me and said, "You know my location. What's up?"
Okay. So, I mean, what I'm hearing on this is that you're saying, well, she instigated some of these contacts, and even if I responded saying you want round two, or, that nonetheless, she was the one that kind of started the back and forth at least.
She instigated a lot of it and still going on with the same things.
Okay. All right. Well, I mean, for today's purposes, in terms of your motion to terminate, I can find that there were two incidents. There was a physical fight, and I recognize every physical fight has two participants, and I'm not going to assess blame for it, but I am going to say, after a physical fight, both people probably feel like, boy, that could get physical again if we run into each other. And that you followed up with text messages, as you acknowledged today, later on in December. It may have been instigated by her, or messages or communications out there, but nonetheless, there was another message where you said, hey, you and I need to get together and we'll have round two. She perceived that as threatening because of what went down before. And I think that was reasonable. I think any reasonable person would say, okay, there's a threat if, Miss Kearney and I get nose to nose together again, it's going to come to hands are going to be thrown, as my kids would say, and that's what these protective orders are intended to do. They can't make you rekindle a friendship or anything of that nature. Don't fool myself that the court has any say in that. However, I sometimes liken it to a boxing match, where the referee gets between the two fighters and says, hey, this round's over. The two of you are going to go back to your corners. You're not going to punch each other for X, Y, and Z of time, until, and of course, our goal isn't that the fight resumes after the bell rings again or something like that. The goal in the community is that, you're not taking matters into your own hands. You're going down the legal route, which is this route that we're on right now, that route of a protective order. So I'm going to leave the protective order in place. I'm not going to hear the testimony about the alleged violation at this time. However, I can advise you of your rights, Ms. Kearney, regarding the hearing, regarding that, and allow you to plead guilty or not guilty at this time. And I do need to warn you ahead of time, Ms. Kearney, and I know I've already, did I swear you in at the start of this, Ms. Kearney?
You did.
I had you take an oath. Yeah. Then you need to know that if I did find that you violated the protective order and I found you in contempt of court, I could send you to the Kent County Jail for up to 93 days and or a $400 fine. You understand that?
Yes.
Okay. And you also understand if you deny that you violated the protective order here, and I'm looking at an incident that involves the candied yam on Division Street, that you're entitled to a hearing. And during that hearing, you're also entitled to be represented by an attorney. And further, I'll appoint an attorney to represent you. If you would like to be represented by an attorney, but you can't afford to hire an attorney of your own choice, that attorney can cross-examine Ms. Jones on her claims that you violated the protective order, and also cross-examine any witnesses that Ms. Jones might call to support her case, as well as use subpoena power to bring in witnesses or evidence that would support your side of the story. So you understand that you have that right to a hearing?
Yes.
All right. And would you like to enter a plea of guilty or not guilty at this time?
Not guilty.
Very well. I will enter a not guilty plea. I will set this matter then for an evidentiary hearing in the future. During that hearing, the petitioner, Ms. Jones, will be represented by the Kent County Prosecutor's Office. I will send you the information to request an appointed attorney if you'd like to do that, Ms. Kearney. Or, of course, if you choose and have the money to do so, you may hire an attorney of your choice to represent you at the hearing. Lisa, do we have a date and time for the hearing?
We do April 24 at 3 o'clock on Zoom.
That hearing to be conducted April 24th at 3 p.m. and I will conduct that via Zoom, although either of you, particularly after consulting with an attorney, may, if you decided for whatever reason you wanted to be in person in the courtroom, you would be entitled to do that. I prefer to do this via Zoom because in particular, in the case of a protective order where you're not supposed to be within a certain, you're not supposed to be able to see each other, well, it ensures that we don't violate that in the courthouse before the hearing. However, I'll conduct this matter via Zoom at that time and date, unless either of the parties object to a hearing via Zoom. In the meantime, the protective order does remain in place. I did note the comment in the response that the two of you go to church together, and I don't ever want to make a protective order something that prevents a person from going to church or going to their job or going to school. My advice to you, Ms. Kearney, as you are the respondent, is you are welcome to go to the same church. However, you should make whatever efforts you can to put a distance between yourself and Miss Jones. That is, not intentionally go in her direction. Now, if she intentionally comes in your direction, then, if she claims a violation, but she indeed is the one instigating it, she'll have a hard time proving that you violated it. The main thing I like to see is that the respondent, which is you in this case, Ms. Kearney, tried your best to avoid anything that could turn into a physical fight. I know it's not always easy, and people get together, and it sounds like there are groups, and it's a, very active church, which is a great thing. I would like, you to both get the benefit of that still, but Ms. Kearney, you're going to have to take the initiative while this order is in place to put some distance between yourself and Ms. Jones. I do note that the order, I think, was granted until July. It'll expire in July of this year. That's the other thing about protective orders, is they're civil matters. It's not as if you have a criminal record coming out of this, Ms. Kearney. A note of the protective order is in the law enforcement information network. So if the police were to be called, they would find that you're the respondent and they would take you into custody. However, if they found that you did some action that could be construed as a violation of the protective order, i.e. that you went to Miss Jones' house, for example, I trust that you're not going to do that. It's only going to remain in effect till July, at which point Miss Jones can apply for renewal if she thinks that it's being intentionally violated during the period, and then it could be extended. It also could run out. These aren't super long lasting things, as legal items go. I know July seems a long way off, sitting here with snow on the ground still, but it'll be here before we know it. And of course, the hope is that, you're both adults, you're both on top of it, church going, adults, who sound to me like, you can, represent yourself very capably, in a setting like this where you're speaking on your own behalf, that, you'll say, hey, I wish the situation was different. It's not exactly like I'd like it, but here's how we get on with life without at least coming to a fight. Because that's what we're trying to avoid here, is kind of the self-help where people go out in the street and throw hands, and then, we get criminal charges and even more law enforcement involvement, and that can have longer lasting repercussions. If you pick up an assault charge or whatever, that can follow you down the road. Whereas a protective order, once they go away for good. I take them out of the law enforcement information network. It's like it never existed. So it's kind of a chance to go back to those corners, take a breather, say, hey, I've got other things in my life. This friendship once was important to me, but, there was a falling out, and I have to set that aside and just, get on with my own life best I can. And, I think you're both, sounds like, very capable of doing that without coming in front of me. So I'll conduct the hearing at the hearing's scheduled date, and I wish the both of you a safe weekend. Thank you.
Thank you.
Fighting on the way to Bible study is not very Christian. I don't know if they were going to a Christian church, but I assume it was. And that's just, well, it doesn't matter what kind of church they were going to. It's not appropriate. So, especially the poor other people that were at church and had to break them up could have gotten hurt in the process. So, these two ladies need to bury the hatchet and not bury it in one another's back, right? So, anyway, thank you guys so much for watching, and I'll see you next time.